so now it's the fall of 2010. Edgar's looking for a new attorney, and through Cindy, you hear of this search for a new attorney.
I offered to represent her because her rights were being abused. As time went on, I realized that Mr. Steele needed a new attorney, and Cindy asked me to go and find him one. We started in the state of Idaho. We couldn't find anybody in the state of Idaho who would represent Edgar Steele. He was so politicized, he was so demonized by the media that the attorneys in Idaho were just afraid. That's part of their program. It's like they're following a KGB playbook, and when they want to target somebody, they go after them, and starting in their community, they make up stories about them, they make them sound like the most horrible person in the world, and then they get the press to publish them.
Close friends of a North Idaho man accused of building 2 pipe bombs in a murder-for-hire plot described Larry Fairfax as a family man. Fairfax was arrested for building explosive devices for Aryan Nation's attorney Edgar Steele. Court documents say Steele wanted Fairfax to kill his wife and mother-in-law.
And when you go to the press and you ask them to publish the other side of the case, they won't have anything to do with it, and they've even told us we only publish what the government gives us. I'm from Colorado originally. I knew Mr. McAllister. He was the chief prosecutor for the United States Attorney's Office in the state of Colorado for many years. A very famous attorney. He became a private attorney and a defense attorney, and a very good one at that, and won some big cases.
And he'd worked on murder-for-hire cases.
He'd worked on murder-for-hire cases, he'd worked on bomb cases, he knew, he'd worked on cases with audio recordings that were phony. He knew what he was doing, and he said 2 things about the Steele case. Number 1, I believe Edgar Steele is innocent, and number 2, he said that, he said, and I quote, "I think I can win this case." So, believing that he was dedicated and having been paid handsomely to defend Edgar, he embarked on representing Mr. Steele, but he did not enter his appearance in the case and become the official attorney for Edgar Steele until February 9th of 2011.
And the trial was scheduled weeks later in March.
The trial was scheduled to start on March 7th, and he immediately asked the court for a continuance, which was denied.
Now, is that usual for a criminal attorney, defense attorney to come in and work the case but not file a notice of appearance in order to gain more time? Is that a normal tactic?
Well, in this case it was a tactic, and he actually explained that to Edgar Steele, that that's what he intended to do, and the government was listening to him. The U.S. Marshal's Office in Idaho actually was arranged for recordings of all of Mr. Steele's telephone conversations, and then they took those recordings to the prosecutor. So Edgar Steele was basically telegraphing his punches. What's important here is these are communications between Mr. Steele and his attorney, and he was not accorded the attorney-client privilege. And so everything that Edgar Steele said to his attorney and everything his attorney said to him went right straight to the prosecutor.
When's Ed convicted? May 5th, 2011.
That's correct.
And then Ed sentenced when?
Early November 2011.
Now, I've got in my hand criminal case United States of America versus Robert T. McAllister et al. 29 count indictment. So this indictment is filed, it's right there at the top. That indictment is filed 11/16/2011 after Ed's been sentenced, after McAllister has botched this trial.
5 days after Edgar Steele was sentenced, this indictment was filed with the court in Denver, Colorado.
They got that indictment ready pretty quick, huh?
No, the indictment was actually issued in July by the grand jury and then sealed and kept hidden so that Edgar Steele wouldn't find out about it. Because if Edgar Steele had known, he would have put in his motion for new trial, hey, the government, which is after me, is also after my attorney. They're investigating, indicting my attorney, and as a result of that, they've compromised my attorney, and I have no way to be properly defended. You can see it in Mr. McAllister's defense in this case. We have since learned that Mr. McAllister was contacted by investigators in early April before the trial started. Mr. McAllister knew that this indictment was coming.
According to the Denver Post article of January 12, 2012, it says, in June, that would be June 2011, McAllister agreed to be disbarred for 8 years for twice using client funds for personal use. 2 months later, McAllister told a judge in Idaho that he had provided ineffective counsel to a client convicted earlier in the year of murder for hire. The trial occurred while McAllister was dealing with his possible disbarment. Quote, at the time, I did not recognize the extent to which my mental state had deteriorated, close quote, as a result of his remorse, McAllister wrote. Further, it goes on to state that McAllister is free on $20,000 unsecured bond.
The very same bankruptcy that he had filed just before defending Edgar Steele apparently was a fraudulent bankruptcy, and he was committing a crime even while he was getting ready to go to trial in Edgar Steele's case. My point is that Mr. McAllister had sold himself out to the same prosecutor so that he hopefully would get some leniency down the road from them, the federal prosecutors, by not properly representing Mr. Edgar Steele. Mr. McAllister failed to make objections, failed to make motions for new trial, make motions for mistrial, make motions to do anything that was in Edgar Steele's favor. And he just sat on his hands the whole time. And as a result, there's almost no record for an appeal, because the only things you can appeal are the things that happened in the trial, and in this case, it's what didn't happen that's absolutely shocking.
I met Ed because he's a very bright guy who is interesting, fascinating conversationalist with a wide-ranging interests, and he and I struck up a friendship 14, 15 years ago, something like that. I was present at Edgar's arrest at his house on the 11th of June 2010, when I actually was called as a witness at the trial. Mr. McAllister asked me the usual introductory questions: what was my name, what was my my relationship, and so forth and so on with Mr. Steele, and then the questions stopped, and I was really tempted to say, but I was kind of afraid of the judge. Aren't you going to ask me this, Bob? Aren't you going to ask me that? But I couldn't really say that. I don't think that's my place as a witness. So I didn't. But I was surprised that he didn't ask me any of the questions that I thought he was going to ask me. He didn't flesh out any of the details. He didn't ask me about the Ukrainian girlfriends. He didn't ask me about what had happened when the FBI had arrested Edgar at his house. None of the things that I thought were important to Ed's case.
My name is Dr. Bob Stoll. I've been an old-fashioned country veterinarian for 30 years. With regards to the Steeles, I met them as soon as they moved to Sandpoint a number of years ago. I had a good feeling right away about the whole family. I had a very good feeling about Ed. He helped me while I gelded his horse. I was subpoenaed to attend Ed's trial as a witness for the defense. When I first met Mr. McAllister, I thought he was very eager and rigorously attempting to protect Ed's rights. After seeing him in action at the trial, I felt that he, at least for the part of the trial that I witnessed, I felt that he was flimsy at best in supporting Ed's side. And when he interviewed me, I felt that he did a very poor job in allowing me to get the substance of my opinions revealed to the jury. It's almost like he was not even on Ed's side. I felt that there was little difference between the way that I saw McAllister work and the prosecuting attorney. If I went in there blindly, I wouldn't have known who was the prosecutor and who was the defendant's attorney.
Now it's day 6 of the trial, and this is the last chance to get a defense audio expert to testify. Here we have page 1361 from the transcript, and it's Judge Windmill speaking to McAllister. Your procrastination does not create my emergency. You made a choice not to subpoena or ensure Dr. Papson's presence here, and now the court is expected to exercise discretion and ignore the rules to allow the witness to testify. That's troublesome. And of course, Papson was never allowed to testify, and the jury heard no evidence from the defense whatsoever about the authenticity or lack thereof of the recordings of June 9th and June 10th. Here we're looking at a memo just after the Daubert hearing, April 21st, 2001, to Edgar's defense attorney, Robert McAllister, known as Mac here. Down towards the bottom, here, underlined, we must bring Papson back for the trial, whatever the cost. We must lay a subpoena on Papson and perhaps move to continue. The subpoena is mandatory for our appeal.
He lied to me, and he said that Ed did not want Papson subpoenaed. And then he was going back to Ed and saying I wasn't on board with Ed's wishes. All along, this was false, because if I knew Ed had ordered or had written a directive and said to subpoena Papson, I would have told McAllister to do that.
He knew he was in deep trouble. He was trying to curry favor with the government by throwing Edgar Steele under the bus. He didn't do anything. His defense was deplorable.
Here's an update. Remember, McAllister was indicted on 29 felony counts. Here's Law Week, posted May 25th, 2012. McAllister pleads guilty to fraud, but he only pleads guilty to 2 counts of conspiracy and 1 count of bankruptcy fraud. Sentencing is set for September 14th.
That I believe in equal rights for all, special rights for none.